Hi everyone, hope you're doing well. Karthik sir here. Today we are going to see the question and answers of chapter number 6 of CA Inter Law Syllabus. And that is in relation to registration of charges. Okay. Pretty small chapter, pretty simple one also, highly scoring, very simple. Ensure that you're gaining as many marks possible in this chapter. Let's go for it. Let's do the question and answer practice. Let's see. Two questions which are similar will be given together. So you can see there I have given these two questions together and they are separated by this word or here. Okay, so let's see this. Mind Limited realized on 2nd May 2021 that particulars of charge created on 12th March 2021 in favor of a bank were not filed with ROC for registration. What procedure should the company follow to get the charge registered with the registrar of companies? Would the procedure be different if the charge was created on 12th February 2021 instead of 12th March 2021? Examine with reference to the provisions of the Companies Act. That is the question here. Okay. So here this question which is given, this is one question that was asked in mock test paper of March 18 and also the CA inter examination of August 18. Okay. Now a similar question also I'll read so that you can get a grip on both the questions. MNC Limited realized on 2nd May 2021 the particulars of charge created on 12th March 2021 in favor of bank were not registered with the ROC. So the charge was actually created on 12th March, but only on 2nd of May they realized that the charge was not registered with the ROC. What procedure should the company follow to get the charge registered? Would the procedure be different if the company realized its mistake of not registering the charge on 7th June 2021? So instead of realizing on 2nd of May, suppose if they realize on 7th of June. So charge was created on 12th March only. But on 2nd June, if they realize that the charge was not registered, what they should do? And if they realized on 7th June that the charge was not registered, what they should do? That is how the two questions have been given. Explain with reference to the relevant provisions of the Companies Act. This was mock test paper, October 2019. Okay, so let's see this. Looking at the question, the section number should click in your mind and it should be section number 77 that comes to your mind. Okay, because we are now dealing with duty to register charge. That is exactly what is section 77. Let's see this. It shall be the duty of the company creating a charge that they should register it with the registrar within how many days? 30 days of the charge creation. If within 30 days of charge creation it is not possible, and if you are looking at a period that is after the commencement of the company's amendment ordinance 2019, so you can see the years in this question also 2021, in this question also 2021 is given, so you understand it is after commencement of the company's amendment ordinance 2019. So you understand that if it is the charge is not registered within how many days? Within 30 days, it can be registered within a period of 60 days of such charge creation on payment of such additional fees as may be prescribed. Correct? If it is not registered in the 60 days also, then they have written here within a further period of 60 days after payment of ad valorem fees, which I've already explained to you many times in the class itself. It's a percentage of the asset. That will be the ad valorem fees. So here they are given the first question. See, first solution. If the charge was created on 12th March 2022 and the company realizes that the charge is not registered on 2nd May 2022, company can get the charge registered within how many days? 60 days from the date of charge creation, because from the date of charge creation 60 days are not done yet. 60 days are not done yet, so you can pay the additional fees and get the charge registered within 60 days. So you can go with this option which I'm going to tick mark here, the second one. So if 30 days the charge is not registered, no problem, then within 60 days it should be registered, because from 12th March 2022 till 2nd May 2022, if you calculate, 60 days will not be over. If you want to try, let's see this. 30 in the month of March, I'll show it here. In the month of March, 31 days are there. How many days are done? 12 days are done. So tell me how many days are left in March, and that will come to how many days? 19 days in March. Plus you can add 11 days of April. So you understand you are adding 11 days of April, or you can do one thing. You can take all 30 days of April here. So I'm writing here 30 here. So total comes to 49. Now you add 11 days here. So May 11th will be the completion of 60 days. But when did we realize that the charge is not registered on 2nd May. So 60 days are not over yet. So you can write in the exam by showing this calculation that the company should get the charge registered by May 11th, because that is the end of the 60th day and the company has to pay additional fees. Now the second question they asked is, sir, suppose a company realizes that the charge is not registered by 7th of June. So in this case, you will realize now this is after May 11th. So after the 60 days are over. But even though the 60 days are over, you still get further period of 60 days. So after 30 days, you get 60 days from the charge creation date. And if it is not registered in those 60 days also, you get further period of 60 days. So after 60 days, further period of 60 days. So you understand 7 June will fall within those further period of 60 days. So company can pay the ad valorem fees and get the charge registered within the further 60 days. Easy to understand this question? Very simple. So this question which you can see here, the solution which I have given you is solved as per this question. Solved as per this question. Type in the comment section below, according to you, what will be the solution for this? When does the 60 days get over? The initial 60 days. So 30, then when does the 60 days get over? And when does a further 60 days get over? Write in the comment section for this question. That will be kind of a practice for you. Next, let's see. Explain the term charge. State the circumstances under which necessity to create a charge arises. What is the time limit for registration of a charge with the registrar? So you have to give the definition of charge. 2 clause 16, you know very well. Charge means an interest or lien created on the property or asset of the company or any of its undertaking, or both as security and includes a mortgage. Easy. What is the charge? So they have written here, see, circumstances when it is necessary to create a charge. When the company raises money through borrowings, they may issue debentures or by obtaining loans from banks or financial institutions. These banks or financial institutions need a surety regarding the repayment of their fund. They should know, okay, even if the company does not pay the loan amount, still we will get our money back. So for that, the company has to give some kind of surety. In this chapter, we see the word security. Security the company will give. Thus, they create a mortgage or hypothecation on the assets of the company for safe and secure lending of the funds. This creation of a right on the assets and properties of the borrower companies is known as the charge on the asset. Is known as the charge on the asset. So we have given the circumstances for which charge is necessary. So we have explained the term charge. We have given the circumstances. Now what limits is the time limit. And time limit, as you know, is within 30 days of creation. And after company's amendment ordinance has commenced within a period of 60 days of such creation on payment of additional fees, and still not done, then you have to make it during the further period of 60 days after payment of which fees, ad valorem fees. Ad valorem fees. As simple as that. Okay. Let's go further. Rose Private Limited on 3rd April 2021 obtained 30 lakhs working capital loan by offering its stock and accounts receivable as security, and rupees 5 lakhs ad hoc overdraft on the personal guarantee of a director of Rose Private Limited from a financial institution. This question I'm marking it a star, slightly different question. So they have taken a 30 lakh working capital loan, giving their stock and debtors, that is account receivable, as security. And they have also taken a rupees 5 lakh loan, that is 5 lakh overdraft facility, I should say, on the personal guarantee of a director, personal guarantee of a director. So you are not giving, you are taking an overdraft facility of 5 lakhs, but you are not giving any asset as security. The director has given his personal guarantee that if the company doesn't pay, I will pay. Like that he has said. Is it required to create charge for working capital loan and ad hoc overdraft in accordance with the provisions of the Companies Act? You have to apply your mind and think. For 30 lakhs loan, you are taking the money from the bank and you are giving the stocks and debtors as security. So is the company giving some asset as security? The answer is yes. So in that case, Companies Act provision will be applicable. Company has a duty to get the charge registered within 30 days. If not, then 60 days. If not, then further period of 60 days. Along with that, ad valorem fees. Correct? But look at this 5 lakhs. When the company takes a 5 lakh loan, has the company given any of its asset or security? The answer is no. The director of the company has given a personal guarantee. So you understand the provisions of registration of charges will not apply for the second part, for this 5 lakh loan, but it will apply to this 30 lakh working capital loan that we are taking. Okay. State the provisions relating to extension of time and procedure for registration of charges in case the above charge was not registered within the 30 days of its creation. So you know very well, if it is not registered within the 30 days, it should be registered within 60 days. So you can see the year here 2021. So it is after the commencement of Companies Amendment Ordinance 2019. So you will write 60 days from the charge creation date, and if not done in those 60 days also, then further period of 60 days along with ad valorem fees. Comfortable? Okay. That is basically given here. See, company is required to create a charge for 30 lakhs working capital loan taken. However, company is not required to create a charge for rupees 5 lakh ad hoc overdraft on personal guarantee of a director of Rose Private Limited, as charge is required to be created on the property or asset of the company for companies as act to apply. But in this case, it is a personal guarantee of the director. Registration can be done in 30 days. If not done in 30 days, then 60 days. If not done in 60 days, then you know very well. Further period of 60 days. With 30 days, you will write your fees. Here you will write your additional fees. And here you will, of course, write your ad valorem fees. Ad valorem fees. Comfortable? Okay, let's go further. Moonlight Limited is having its establishment in USA. It obtained a loan there, creating a charge on the assets of the foreign establishment. The company received a notice from the registrar of companies for not filing the particulars of charge created by the company on the property or asset situated outside India. So they are clearly given that the asset is situated outside India. Jan 2021 3 marks question. The previous one also November 2020 4 marks question. Okay, so important questions that can again come in the examination. Situated outside India. So the asset in this case is situated outside India. So Moonlight Limited is having establishment in the USA. They obtained a loan there, creating a charge on the assets of the foreign establishment. The company received a notice from registrar of companies. So Moonlight Limited is having an office in the USA, establishment in the USA, and they have given an asset as security, which is there in the USA only. The company wants to defend the notice. Company is saying, how can you ask us to get the charge registered? The asset is situated outside India. So company wants to defend the notice on the ground that it shall not be the duty of the company to it shall not be the duty of the company. It should be here too. Okay. To register the particulars of the charge created on the assets not located in India. Do you agree with the stand of the company? Give your answer with respect to the provisions of the Companies Act. Whether the charge is created within India or outside India on a property asset undertaking located within India or outside India. That is what is written in section number 77. So you understand, even though the property is situated outside India, still we have to get the charge registered in India. Simple. So you understand here, see. It shall be the duty of the company creating a charge within or outside India on its property or asset or any of its undertaking, whether tangible or otherwise, and situated in or outside India, to register the particulars of the charge signed by the company and the charge holder. Charge holder means the person who is giving the loan and to whom we are giving the asset as security, together with the instruments, if any, creating such charge in the form on payment of such fees and in such manner as may be prescribed with the registrar within how many days? Within 30 days of creation. Moonlight Limited is incorrect in their stand as they did not register the charge, because even though the property is situated outside India, they should have registered the charge. Okay. I am giving the hint of the answer here. Okay. So you understand what is the crux of the matter that should definitely appear in your paper, so that you stand a chance to score excellent marks in the examination. So you should definitely write this part. Okay, let's go further. Define charge, which you very well know, 2 clause 16, we had done it earlier. Who has the authority to verify the instrument of charge created for property situated outside India? So who will verify the property situated outside India? Remember the 5 fingers. Okay, seal of the company is this finger. This finger is a hand of the director, that is signature of the director, signature of the company secretary. Then you have the authorized person of the charge holder, and finally any person who is interested in the mortgage. Any person who is interested in the mortgage in relation to that property. So you understand here, the property is situated outside India. In that case, it should be verified by the seal of the company, hand of any director or hand of the company secretary or an authorized officer of the charge holder, that is the authorized officer that the bank appoints or the lender appoints, or under the hand of some other person other than the some other person who is interested in the mortgage or charge. So the five fingers. Let's see, we learned it like this. So this was only for outside India. Look at this question, see, direct question. How will a copy of an instrument evidencing creation of a charge and required to be filed with the ROC be verified? Who will verify that the charge is required to be created on this particular property? So who will verify it? Again, I told you the same thing, that is your seal of the company, hand of the director, hand of the company secretary, authorized officer of the charge holder, and the final will be a person who is interested in the mortgage. Simple. This is for outside India. But when it comes to property which is located in India, now you will not write this point, you will not write this point, and you will write the other three. You will write this one, you will write this one, you will write this one. In the class, we did these five fingers for outside India and these three for within India. Comfortable? Let's go further. Mr. Antriksh purchased a commercial property in Delhi belonging to NRT Limited, entering into an agreement with the company. At the beginning of registration, Mr. Antriksh comes to that the title of the company is not free, and the company expresses its inability to getting the title transferred in his name, contending that he ought to have the knowledge of charge created on the property of the company. Explain whether the contention of NRT Limited is correct. Look at this RTP May 18, mock test paper October 19. This should be I think May 21 examination. I think it should be May 21, and then it was November 21. Okay, I may be wrong. It can be March, but I think it is May 21. So what I mean to say is 4 times it has been referred by the ICI, once in RTP, once in mock test paper, twice in the examination. Antariksh is saying that this NRT Limited has given them an asset as security, but the property papers they are not able to give Mr. Antariksh. So Antariksh is saying, what is this? I have given I have purchased an asset from you. He has purchased an asset from the company. Why can't you give me the property papers? Company saying, boss, that property papers are there with the bank. Till the loan matter doesn't get paid, the bank will not release the papers. Antarik said, oh, you should have told me regarding this earlier. Who would have told me regarding this? Company saying, boss, you should have known that the charge is already registered with the ROC. You should have known. Antariksh is saying, how will I know? I will not know. Is Mr. Antariksh correct? So they are given here C. Or you can say like that, is NRT Limited is correct? He's saying that Antariksh should have known about it. The answer is yes, NRT Limited is correct because you know section number 80. Where any charge on the property or asset of a company or any of its undertakings is registered under section number 77, any person acquiring such property, asset, undertaking, or part thereof, or any share or interest therein, shall be deemed to have notice of the charge from the date of such registration. As per the above provision, Mr. Antriksh ought to have the knowledge of the charge from the date of registration. He should have had the knowledge. Comfortable? Hence, the contention of NRT is correct. Hence, the contention of NRT is correct. Easy? Okay, let's go further. State with reasons whether the following statements are true or false. Let's see. The registrar of companies is not bound to issue notice to the holder of charge if the company gives intimation of satisfaction of charge in specified form and it is signed by the holder of the charge. The loan amount has been satisfied. Company is required to give intimation. Company does a very nice thing. Company first takes that intimation of satisfaction of charge to the bank or to the lender or to the charge holder, whoever it is. And the charge holder then signs saying that yes, you have paid the loan amount, we agree. And then the company goes and gives the intimation of satisfaction of charge to the ROC saying that, see boss, the loan amount is fully paid. And see, the charge holder has also signed it. So in this case, they have asked, is the registrar of companies bound? Is the registrar of company, they have given the sentence, the registrar of companies is not bound to send a notice to the charge holder because the charge holder has already signed. Are they correct? The answer is yes, true, correct, true. As the charge holder has already signed the intimation of satisfaction of charge, so it is a proof that the charge holder is aware regarding the intimation of satisfaction sent to the ROC, sent to the ROC. Comfortable? Further. The registrar of companies may allow the company or the holder of charge to file intimation within a period of how many days? 300 days of satisfaction of charge on payment of fees and additional fees as may be prescribed. That is what they are given here. So the registrar may allow intimation to file within a period of 300 days if you have not filed the uh, intimation of satisfaction of charge within 30 days. So will they allow 300 days? The answer is yes. This is given in section number 82. It is given in section number 82. True, as it is mentioned in section number 82 that if the intimation of satisfaction is not given within 30 days from the date of satisfaction or payments, then it can be intimated within how many days? Within 300 days from the date of satisfaction. Sorry for this. From the date of satisfaction, once again, date of satisfaction or payment along with additional fees, along with the additional fees. Comfortable? Okay, let's go further. DL Limited hypothecated its plan to a nationalized banks and availed a term loan. The company registered the charge with the registrar of companies. The company settled the term loan in full. Company has paid the entire amount. The company requested the bank to issue a letter confirming the settlement of the term loan. The bank did not respond to the request. State the relevant provisions of the Companies Act 2013 to register the satisfaction of charge in the above circumstances. State the time frame up to which the ROC may allow the company to intimate satisfaction of charge. Very simple question, November 15, 5 marks they have asked. So company has is planning to give the satisfaction of charge and they have given the time limit period for this. So section number 82 you have to explain in full. Company shall give intimation to the registrar within a period of 30 days from the date of such payment or satisfaction in which form CHG4 along with the fee. The registrar may on an application by the company or the charge holder allow such intimation of payment or satisfaction to be made within a period of 300 days on payment or satisfaction on the payment of such additional fees as may be prescribed. Comfortable? That is what they have given. Simple answer. Ranjit acquired a property from ABC Limited, which was mortgaged to OK Bank. So this is the situation. ABC is there, ABC Limited. ABC Limited must have taken a loan from the bank. So bank must have given loan to them, and ABC Limited mortgaged a property. So ABC Limited mortgaged a property. I'm writing here MP mortgaging of property, and the ABC Limited had taken a loan from the bank. Comfortable? Now this property which was there, okay, so I'm just going to show the star. Imagine this star as a property. ABC Limited mortgaged this property to the bank, and mortgage means they gave the bank the property papers. And ABC Limited then sold this property to another company, and that is, to another person, I should say, and that is Ranjit. So Ranjit in this case got the property. He settled the dues to OK Bank. So Ranjit then later on, as per the agreement, paid off the entire loan amount to the bank. Okay. So let's say Ranjit, the arrangement between ABC and Ranjit was such that Ranjit had to pay the loan amount. So Ranjit has paid the loan amount now. He has settled the dues to OK Bank in full, and the same was registered with the sub-registrar, who has noted that the mortgage has been settled. But neither the company nor OK Bank has filed particulars of satisfaction or charge with the registrar of companies. So the company also did not inform the ROC. Ranjit also did not inform the ROC. Comfortable? So, sorry, the company has also not informed the ROC. Once again. And the bank also has not informed the ROC. Bank has also not informed the ROC. So let's say here is the ROC. Okay. So they are given here, see, can Mr. Ranjit approach the registrar? Now a third party wants to approach the registrar. Third party wants to approach the registrar. So this is the charge creator, correct? ABC Limited. This is your charge holder, correct? Bank. Both have not gone and informed the ROC that Ranjit is the new owner. So Ranjit wants to go and inform the ROC along with proper evidence and everything. He wants to go and inform the ROC. So can a third party go and inform the ROC? The answer is yes, and that is given in section number 83. Comfortable? So see what they are given. Power of registrar to make entries of satisfaction and release in absence of intimation from the company. Entire section 83 is given here. Entire section 83 is given here. The registrar may, on evidence being given to his satisfaction that the debt for which the charge was given has been paid or satisfied in whole or in part, or the property or undertaking charge has been released from the charge, or has ceased to form, this is the question that they were, ceased to form part of the company's property or undertaking. So because the property or undertaking now is not the part of the company's property anymore, ceased to form part of the company's property or undertaking anymore, and Ranjit is going with all the look here, all the evidence with the to the registrar. In that case, registrar will hear Ranjit's case because third party can also intimate the matter in relation to any charge. Simple. That is especially in relation to satisfaction of a charge. Simple to understand here, easy to get it. That entire section is given here. So 83 you can just simply read, you will come to know the answer. So here it is given, Ranjit can approach the ROC and show evidence of satisfaction of charge. Simple. Let's go further. What are the powers of registrar to make entries of satisfaction and release of charges in the absence of any intimation from the company? Discuss this matter in the light of the provisions. Look at the reference. RTP November 19, November 20 exam, mock test paper October 18, March 19 examination. You can see many times. So they have given here, see the entire section number 83 given again, entire section number 83. As simple as that. And these are the direct questions that come in the exam. See, direct question. Not case study, directly given powers of the registrar to make entries of satisfaction in the absence of intimations. Directly pointing to you that please write section number 83. Here also we saw one more question here. We had seen one more question once again, and this was this one. See, direct question. This is called direct question. No case study, direct question. So you have to directly come to the point and just score the marks. As simple as that. Okay. Now this is a case study based question. Again, see this one DL Limited, a case study based question. So all these are the case study based questions. Okay. Let's go to the next area. Let's see this. Define the term charge, which you know very well, 2 clause 16. Also explain what is the punishment for default. You know very well punishment for default is given in section number 86. So that's section number 86 you have to write. As simple as that. Explain the provisions of Companies Act relating to rectification by central government in register of charges. Mock test paper March 18, August 18. So they have given here see section number 87. Section number 87 clearly entire given again a direct question. So direct question you can simply just write that section. It is about writing the section. Okay. So you should know the section. So section number 87 is given, and if you read section number 87, you know it is written along with rule 12. It is written along with rule 12. So 87 and rule 12 are given here. So you have to ensure that you know those provisions first. So the step one for learning is know the content, know the provisions properly, how they apply, know it properly. Step number two is this video where you will see a question and you will see in the past what kind of questions have come and then how the solution is given. Step number three was the revision video so that you are revising it at regular intervals so that the concept stays in your mind. Then finally ensure that the MCQ questions are solved. These four steps, if you do in law, you will score excellent marks in law. Okay, let's see this. Let's go further. ABC Limited created a charge in favor of OK Bank. The charge was duly registered. Later, bank enhanced the facility by another 20 crores. So there was modification, correct? No. Earlier, the charge was duly registered and then the bank provided more 20 crores as loan. Due to inadvertence, this modification in the original charge was not registered. This was not registered. Advise the company as to the course of action to be pursued. So if you have not registered within 30 days, 300 days, further period, if you have not registered the charge or the modification, whatever it is, the creation of charge modification, if you have not done it, so you have to go to the CG and get it rectified. So you know you have to write section 87 along with rule 12, along with rule 12. The same thing which I showed here, section 87 along with rule 12. Easy, but here you see that it is given in a case study format. Same thing, one earlier given in the direct question format, this is given in the case study format. Simple. That's it. That completes our question and answers for chapter number 6, that is registration of charges. If you like this format in which we are doing it, please ensure that you are liking the video, you are sharing it with your friends, okay? And any other series that you want me to make so that it is helpful for your preparation, type in the comment section below, okay? You can also get in touch with me through Instagram where I am more faster in responding to queries and matters. So ensure that you're getting in touch with me and you're solving all your queries to score excellent marks in the examination. I wish you all the best. Take care. Bye.